If your mom owns a home worth $1 million, but she still owes $700,000 on it, how much do you think your family could lose to probate court? Most people guess based on $300,000 in equity. The real answer is, I guess I should have had this ready, but I didn't. Well, we're going to go by it. The real answer is that the fees get calculated on the full $1 million. And that is just the first surprise. I am Ron Siegel, certified liability advisor, helping families build wealth through strategic debt management. I am not an attorney. I do not sell estate documents. For more than 40 years, since 1983, I've helped families protect the biggest asset most of them will ever own, which is the home. And probate sits right where the home, the mortgage, and the family all come together. It's not something most people face every day, but when it comes hard. So it's worth understanding before you need it. Let me start with the thing almost nobody knows until it's too late. When someone passes away and owns a home in their name, that home does not just flow to the family. In many cases, it has to go through a legal process called probate. Probate is the court's way of proving the will, paying the final debts, and moving what is left to the right people. Here's the part that shocks folks. Having a will does not avoid probate. A will just tells the court who you want in charge and who you wanted to inherit. The court still runs the show. The only reliable ways to keep the home out of probate are set up while you're still living. Now, there is some good news for California families in 2026. A new law called Assembly Bill 2016 took effect in 2025 and made it easier for a lot of people for deaths on or after April 1st, 2025. A person's main home worth up to $750,000 can now pass through a streamlined court petition instead of a full probate. That can save a family a year or more, but listen closely because there are conditions. It only works for the primary residence. It does not cover a rental or a vacation home, and the home is worth more than $750,000, and it is not in a trust. You're most likely headed into full probate. So what does full probate actually look like? Let me walk you through it because this is where families get blindsided. First, the time. California probate typically runs 12 to 18 months. Simple cases might close in 9 to 12. But if there is a fight among the heirs or the case is in a busy county like Los Angeles or Orange, it can stretch past 2 years. And here's a floor you can't get around. There is a 4-month window where creditors are allowed to file claims, and that window cannot be shortened. So even a perfect, simple probate almost never closes in under 6 to 8 months. Second, the cost. California is one of the few states that sets attorney and executor fees by law as a percentage of the estate. And two things about those fees really sting. Number one, the fee is paid to the executor and then again separately to the attorney. So the ordinary cost is basically double. Number two, and I mentioned this at the top, the fee is calculated on gross value, not on your equity. Let me give you a real example. Take an estate worth $600,000. The statutory fee works out to about $15,000. Pay that to both the executor and the attorney, and you're at $30,000. Add in court filing fees, the appraiser, publication, and a possible bond, and you're looking at around $32,000 to $34,000. Gone. Money that was supposed to go to the kids. Let me tell you about a client situation that stays with me. A woman's mother passed away last year. The family thought they could close mom's bank account with a death certificate and sell the house. That is not how it works. The bank froze the account. The title company would not transfer the property. Everything locked up. Why? Because mom did not have a living trust. So the estate had to go through probate. 18 months later, they were still waiting and the fees kept climbing. Now, why can families not just walk in with a death certificate and take care of it? Because the moment a death certificate is filed, that information travels electronically to Social Security, the banks, the institutions. Accounts get frozen. Title companies will not move the property. The system stays locked until someone has legal authority, and that authority comes from one of the two places. the probate court, or a living trust set up in advance. There is one more trap I have to warn you about because it catches more Californians and families than any other. It is called Proposition 19. When you inherit a parent's home, you do not automatically keep their low property tax bill. If you do not move into that home as your primary residence and file for the exemption within 1 year, the county reassesses the property to full market value. I've seen families plan to keep mom's old house as a rental only to watch the property taxes double or triple overnight. Nobody warned them, so consider yourself warned. And here's something else about probate that people do not realize. It's public. Once the case is opened, the will, the list of assets, the values, the names of all the heirs become public record. Anyone can look it up. A living trust, on the other hand, stays private. So what does all of this mean for you? It means the time to plan is now while everyone is still here. A living trust is not just a document, it's a system. The paper is maybe 20% of the job. The other 80% is doing it right. Funding the trust, make sure the home's title actually matches the trust, making sure the mortgage and the property tax strategy line up. I've watched families with the same house end up in completely different places. One printed a document and filed it in a drawer, never changed the title, and walked right into probate anyway. The other had a professional check every piece. On paper, they both looked protected. Only one of them actually was, and you never see the difference until the moment it matters most, when it is too late to fix. Remember what I always say, strategy beats rate always. That is just as true for settling an estate as it is for a mortgage. A little strategy now can save your family many months and tens of thousands of dollars later. So here's what I want you to do. If you have a trust sitting in a drawer, or you've been meaning to start one, or you're helping a parent think this through, let a professional pressure test it. I work with an attorney-supervised trust firm that handles this the right way. Go to rsrlinks.com/estate. That's rsrlinks.com/estate. Let real professionals make sure your family is actually protected and not just holding a nice looking piece of paper or book. I am Ron Siegel, your certified liability advisor, helping families build wealth through strategic debt management. Thanks for listening to the Borrow Smart segment, brought to you by rsrwealthbuilder.com, rsrwealthbuilder.com.